Carney against Adams is a lot more concrete than your First Amendment hypothetical. I mean, these cases are hard enough when you're trying to figure, well, what is the weight of the infringement on the First Amendment values, against what is the protective effect on potential corruption. I mean, I don't know how you do that in the first place, but to say that the standing is going to depend upon a particular calculation, I think it's much more concrete in Carney against Adams when you're asking, well, would somebody really go to, go run for office? That's also hard, but not anywhere approaching the indeterminacy of the calculation we're supposed to make here.
Well, I think the calculation on the merits may be difficult, and it may involve a complicated balancing, but the calculation on standing, I think, is very straightforward. If the appellees had filed their suit 7 days before the election and they had said in their complaint, Senator Cruz has no intention of loaning money to his campaign regardless of the outcome of this suit, but he feels strongly that the statute is unconstitutional and he would like a judicial determination to that effect. Clearly there would have been no standing, whatever the court thought of the merits of the constitutional claim. And what we have here is essentially that. That is, appellees have stipulated that if there were no statute, if there were no reg, they never would have made the loan and they would have promptly repaid it if the loan had been made. And so the question—
it's just sort of, I mean, there's test cases are not always, you don't always have a lack of standing. If you get people challenging discriminatory housing practices and they go in and say, we're thinking about buying this house, and they're discriminated against because of their race, and they don't say, well, whatever, you can't buy the house. They don't have to go in and prove that they would actually buy the house, do they?
Well, if they were, they might not have to prove that they would buy the house in the same way, for instance, that in the school admissions cases where you have use of racial criteria in school admissions. The plaintiffs don't have to show that they would have been admitted if the laws were different, but they do have to show they were ready and able to apply. And the question here really is, if they didn't have standing 7 days before the election, can they manufacture standing by voluntarily subjecting themselves to an injury solely for the purpose of facilitating a lawsuit? I mean,
Mr. Stewart,